Good afternoon, everybody. I'm Stephen Matter. I'm the Dean of the KU Law School. On behalf of the entire law school community, welcome to the 2016 Diplomats Forum. The Diplomats Forum is the most prestigious international event of our academic year. As with our entire international and comparative law program, the aim of the Diplomats Forum is, and I quote, to help build bridges across countries, cultures, economies, political systems, and religions. It is an important part of our mission to prepare world-class international lawyers committed to the rule of law and the principle of justice. The Diplomats Forum is designed to encourage a candid sharing of thoughts on international law and relations by an invited speaker with notable experience in international law. Our lecturer today, Dr. Obiora Okafor, is a professor in the York Research Chair in International and Transnational Legal Studies at York University's Osgoode Hall Law School in Toronto, Canada. He has a very impressive record of scholarship and involvement in important human rights organizations. He has published extensively in the fields of international human rights, as well as immigration and refugee law. He is the author of 3 books: The African Human Rights System, Activist Forces and International Institutions, Legitimizing Human Rights NGOs, Lessons from Nigeria, and Redefining Legitimate Statehood. He has authored over 70 articles, book chapters, and other scholarly writings, and he currently serves as editor of the Transnational Human Rights Review. He has received numerous awards for his work. He has served as a MacArthur Foundation Visiting Scholar at Harvard Law School's Human Rights Program, a Canada-US Fulbright Scholar at MIT, and he has served as a visiting professor at universities in France, Uganda, and Nigeria. He holds law degrees from the University of Nigeria and an LLM and PhD in law from the University of British Columbia, where he was awarded the Governor General of Canada's Gold Medal Prize for Academic Research Excellence. Dr. Okafor currently serves as chairperson of the United Nations Human Rights Council Advisory Committee. The title of today's presentation, which will be followed by a Q&A session, is International Legal Accountability and the Right to Development, an African Perspective. It is with great pleasure and honor that I give you the 2016 Diplomats Forum lecturer, Dr. Obiora Okafor.
Let me begin by expressing thanks to Dean Maza Sobala, who I just reminded that he spoke to my class remotely 10 years ago. Various other people who made strenuous efforts to make sure that I come here today and that this event is a success. I'm grateful for the invitation. I'm very pleased to be here. This very wonderful campus, and I must say this, Professor Bala just told me outside at a school that admitted blacks 75 years before Harvard. I think that's something I should be real proud about. Professor Bala's initial invitation charged me to be frank and to broach a topic that people might not be as familiar with. And the presentation today, in part, response to that charge. I took it seriously, and I said, okay, what might I talk about that perhaps we don't talk about as much these days, but it's nevertheless current, if you like, in the diplomatic hallways and in diplomatic rooms, both in Geneva and New York. And hence the choice of today's topic, international legal accountability in the implementation of the right to development from an African perspective, not simply because I'm African, not simply because I sit as a Nigerian, I'm an independent expert, but I sit as a Nigerian on the UN Human Rights Council Advisory Committee, but because, in fact, on the question of international legal accountability, this is one area in which normatively and in terms of mechanisms that the African system actually points in a direction which, to my mind, is the right direction and leads the way. So the African perspective there comes from multiple points, not just in terms of my background. And so I'll go right straight to the talk, if you don't mind. I'm going to shorten what is a much larger paper, much to your relief, I'm sure. So the recent adoption of the so-called Sustainable Development Goals, I don't know if anyone has heard about it here, probably Professor Valos heard about it, but these are goals that have replaced the Millennium Development Goals, which for 15 years the world, if you like, strove to reach. Those goals in terms of international cooperation to lift people out of poverty and achieve several other development benchmarks. So the Sustainable Development Goals expired in 2015. The Millennium Development Goals expired in 2015, and the Sustainable Development Goals recently adopted. The summit late last year replaced those. So their recent adoption signaled that perhaps the implementation of the right to development will take center stage post-2015 in a way that we have not seen before, at least on paper. And this premise led me to this paper, right? So that is the way at least it is being presented, that something new is happening in the world, and I'll talk about this soon again, but according to the language that the UN has used, there's going to be big transformative shifts happening, okay? And in some ways, yes, but I want to examine and probe to what extent this is correct, and to what extent there needs to be more attention paid to international legal accountability, not just accountability, but legal accountability in ensuring that indeed those sustainable development goals are attained at the end. So that, in a nutshell, is sort of the direction of the paper. Okay. So I would like to give you a roadmap to my presentation. So I'll begin with a background, which I think is important, and then I'll look at this question of international legal accountability on the African plane. Okay, and then thereafter I'll look at this question on the global level, and then I'll have some words to say about whether hard law can come to the rescue. Obviously, but if you look at that, you see that I would have arrived at a gap by this time, or not so fast, whether it wouldn't come to the rescue of the sort of the gap that I identified, and then some concluding remarks. All right, so so the adoption of these sustainable goals was quite significant, given the controversial history of the right to development. Not everyone, as I said at the outset, might have been following the sort of, if you like, the development of the right to development, its career. But I'll say a few words about that. So, in the 80s, thank you, sorry, early 90s, 92, actually this was 86, the Declaration on the Right to Development was adopted by the UN, largely pushed by a coalition of so-called developing countries, heavily contested by developed countries. I don't think I need to define those terms. I think people have a general idea of what I mean when I say that. So it was contested largely on the grounds, for example, that if developing countries, the peoples of developing countries were to have a right to development, on whom shall the obligation to develop them fall? So these were some of the controversial questions, as you might imagine. So it was quite controversial. However, by a process of attrition, perhaps, starting with the Rio conference and then the Declaration on Environment and Development in 1992, the Vienna Declaration on Program of Action, which followed the World Conference on Human Rights in Vienna. Starting with all that, which was in 93, and many other, if you like, soft law. I don't know how many lawyers are here or non-lawyers, so I'm not so sure what terms to explain or not. But the difference between soft and hard law is hard law is supposed to be binding and enforceable. Soft law is just mostly to be a grounds for persuasion. So there's a kind of rough distinction between hard and soft law. So many other sort of soft law documents being produced. The right to development has come to stay in the discourse and practice of the United Nations, in the discourse and practice of international relations. Okay, so that whether or not it exists is not really so much the controversy at this point. The debate has shifted to accountability. How do you actually implement it? And that's why the paper is about implementation. I believe I can talk the whole day about the 70s debates, but I don't want to be so retro. Okay. Now, so a seeming turn, therefore, to a more serious attitude to the implementation of the right to development was signaled by the adoption of these goals, the Sustainable Development Goals, and this was preceded by the adoption of the high-level panels report. The UN constituted a high-level panel to study the issue, and they adopted a report. This report, which was actually backed by the UN Secretary General's report, recommended that the world take 5 big transformative shifts, or like a US politician says, huge shifts. I say that a little bit tongue-in-cheek. So 5 big transformative shifts were recommended in first this high-level panel's report, in UN Secretary General's report, and there was also this felt need within the UN, outside the UN, among discerning observers, that there needs to be something put in place to fill the vacuum that will be left by the expiry of the Millennium Development Goals. But that whatever replaced it must respond to the need for these big transformative shifts. Okay? And so what are those 5 big transformative shifts that were called for? The first was a radical move, really, if it's implemented, from a discourse and practice about reducing poverty to a discourse and practice about ending poverty as we know it, and extreme poverty as defined as people who live on less than $1.25 US dollar 25 cents a day. Okay, so this was the definition of extreme poverty. Not simply reducing it, but ending it by 2030. This is radical. For the first time, the UN spoke in this way. Okay, even though of course that defines out a lot of poverty, but even ending that extreme poverty, not simply reducing it, was a big shift. Okay, so that was supposed to be one of them. So a normative shift, a practical shift, a shift in mentality as well. And the second big transformative shift was to put sustainability at the core of development. So not simply develop ourselves out of existence, but have some notion of sustainability. The third was to transform economies for jobs, not just jobs, but also inclusive growth. So the notion that simple growth was not enough, that you had to include people as the economy grew. Okay. The fourth was to build peace, as well as open. Is that the fourth or fifth? I didn't speak. Is the fourth? Yeah, okay. Yeah, was peace. And then the fifth was, so fourth was build peace, and the fifth, to build an effective, open, and accountable institutions for all, and then to forge a new global partnership based, in part, at least, on accountability. So you see accountability featuring in at least two of these transformative shifts. So reading the high-level panel's report, reading the Secretary General's report that endorsed it, the UN Secretary General's report, you would think that accountability will become central to the SDGs when they're adopted, the Sustainable Development Goals, okay? Remember, these were the reports that preceded the SDGs. Now, the previous approach was incremental, as I said, right? That was the mentality. This was a shift away from that incremental approach. So I have to keep circling between the two sort of, if you like, media. Now, furthermore, if you read the UN Secretary General's report itself, it even talked about the need to establish, quote unquote, participatory monitoring framework for tracking progress. In other words, no longer platitudes, right? We have to monitor progress, track it. If you say you're going to commit X dollars, we see whether you committed it or you just made the statement and went to sleep, right? Which mirrors much of history, right? And his report also talked about establishing mutual accountability mechanisms for all stakeholders. This would have been radical. This is UN language, but really meant both for developed countries and developing countries. That's what he'd be trying to do. Now, this was ambitious, given the history of what I call accountability avoidance in this area, right? There's been studios, not just on the global level, also at the national level, at the regional, for example, African level, at all levels. States don't want accountability to be tracked, monitored, named and shamed on this issue. Developed countries don't want it, developing countries don't want it. So there's this kind of unhappy, if you like, coalition of accountability avoidance, essentially, that play in this area of the right implementation of the right. That was a historical experience. Now, but as if this wasn't ambitious enough, even more ambitious in the Secretary General's report about implementation of Sustainable Development Goals, SDGs, was the notion that the SDGs were not realizable at all without respect for human rights, not just human rights, but the rule of law. This was all in the report. You can read it for yourself, okay? Now, but included in that report, though, as well, was a damper, okay? In case you got away with dreaming too much. And this damper was that, to the trained eye, if you read carefully, you would see that when it came to the rule of law, not simply broad talk about accountability, but when it came to the rule of law discussion applied only in terms of state behavior toward citizens. Okay, there was no notion of the rule or discussion of the rule of law in terms of global level play. Okay, so on the one hand, you had an accountability discussion on a broad level, but once law is mentioned, it then becomes states toward their citizens. No notion of rule of law applying when a state says we will transfer funds for development, right? So, but you have to read carefully to see that this is a limited notion of the rule of law that is in play here. So it's limited to national level accountability in reality and very light on global level accountability. Because once you take law out, and this is the gravamen of my contention in the end, accountability begins to dissipate, especially given the historical behavior of actors in this area, right? Now, so I find myself a little bit on my side, almost defending hard law in this paper, while in fact a lot of my work has been actually arguing in favor of soft law. But I hope that at the end you will see why this makes sense in this area. Now, and so it was a big problem, this way in which rule of law becomes circumscribed, even at the level of the Secretary General's report. Even more troubling, perhaps, is that following the adoption of the Secretary General's reports, states could then not even agree on the broad notions of accountability. So when you get to the SDGs themselves, the Sustainable Development Goals, even the broad language of accountability becomes watered down. So if you look at the SDG on international partnership, I think it's SDG 18 on international partnerships in this area, what you see is the usual tried, tested, and not very effective approach of saying, let's leave it to the goodwill of countries, right? Especially donor countries. So yet again, we have accountability avoidance. And of course, there's a logic to it. It's not a simple accident, right? So the question then is, how might such platitudes that we're left with convince rich states to deliver on their ambitious promises to provide the capital, the technology, the market access, and the human resources that the poorer states need? It is all great to talk a good game about development, but if you break it down, if you have to develop, you need capital, you need technology, you need market access, you need human resources, and much more, right? This is, if you like, what Carlson used to call the process of concretization. When you concretize it, that's what it really means, right? So, but how might such platitudes about global cooperation and international partnership, placed against a background of probably close to 100 years of similar platitudes, not getting us anywhere really, or not getting much done, how might this then lead us to remember the big, huge transformative shifts that I talked about? On the one hand, so you have this ambition for huge transformative shifts occurring, and on the other hand, you have a failure to track, monitor, and institute accountability. So the question is, how might this then produce, this approach produce such shifts? What are we to make of this? What ought to be done, or can and ought to be done, to strengthen international accountability and therefore enhance success in the implementation of the right to development? Now, what I want to do is, in turn, to focus on A, the African context, and B, to thereafter focus on international, also global, because the African context is international, the global context. And as I've said, the African context is particularly important because the African Human Rights Charter contains one of the precious few hard law guarantees of the right to development. So a skeptic might say, well, we've tried hard law as well, it hasn't worked, Africa is not developed because you have law, right? That's a legitimate argument, question you might ask, right? So that's why I want to look at the African context. In fact, does hard law matter, right? Because we do have hard law, not at the global level, but at the Pan-African regional level. Does it matter? Has it added value in any way to the struggle to implement the right to development at any level, okay? So that's the overarching question when I look at that issue. But my overall argument here is that given a history, and I'd like to emphasize this, a history of the avoidance of accountability, and given that that history is at the root of the relative failure of previous international development agendas, we cannot continue to do the same thing and expect a different result. And here again, I'm quoting another US politician, now your president. You can't keep doing the same thing and expect a different result. It's not going to work. Okay? And that's exactly, unfortunately, what the SDGs do when it comes to international legal accountability. So, and this is a continuation of that argument that as such, hard law norms and strong accountability mechanisms must be deployed to the task if the current SDGs are to succeed better than those that they replaced, the goals that they replaced. Especially because we have very ambitious objectives in the current SDGs. Now, so the rest of the presentation will be devoted to looking at those two levels, the African level and the global level. Okay? So that's what the Article 22 of the African Charter on Human and People's Rights says. Okay? This is where that notion of hard law accountability comes. It's a little vaguer than the jurisprudence, which interprets it as made it, but this is what it says essentially. All peoples shall have the right to the economic, social, and cultural development with due regard to their freedom and identity in the equal enjoyment of the human heritage of mankind. It's a bit flowery and vague. States shall have the duty, individually or collectively, to ensure the exercise of the right to development. Of course, what they mean by states here are African states, because no other states are parties to the African Charter. The US, for example, will not be a party to the African Charter because it's not an African state. It's last time I checked. Peoples, what does it mean? We'll come to that, okay? Excuse me. So to emphasize, unlike the position at the global level, the right to development in the African Charter is a binding hard law norm, okay, provision. It's supposed to bind states, although at an international level, African international level. Now, the notion of peoples in Article 22 has been interpreted in a long line of decisions by the African Commission on Human and People's Rights, which is the commission charged with monitoring the observance of states with this provision, to mean something which I'm sure when the states adopted this document, they did not have in mind. Now, I don't want to get into arguments about strict constructionism and the US Constitution and all that. But, you know, similar arguments are clear. But the point is, the jurisprudence is clear. The jurisprudence is clear that the peoples mean the peoples of the state, not the state itself. In other words, the state cannot have obligation to itself. The state owes obligation to the people. And those peoples include subgroups within the state. Indeed, all the cases, long line 9 or so cases that I've identified, are all brought by subgroups. Not all of them were successful or equally successful, but they were all brought by subgroups, indigenous peoples, ethnic groups, some other kinds of groups, against African states. Right? At the African Commission saying, you have violated our right to development in various ways. Right? So I'll come to that, but I just wanted to flag that point, that under this provision, that subgroups can litigate against the state at the African level, at the African Commission, and if certain procedural requirements are satisfied, I won't get into all the technical details, also at the African Court of Human and People's Rights. Now, this is different than the jurisprudence of, say, the Inter-American Commission and Court on Human Rights, which has held that the peoples refers to all the peoples of the state, not subgroups. And as we'll see as we go along, this has had a lot of consequences, very important consequences for, if you like, the right to development. Now, so to what extent then has the guarantee in this provision, Article 22 of the African Charter, been translated into real-life benefits for real people, for peoples in Africa? To what extent? That's the real question, right? To what extent has it been translated? Have real people mobilized on this provision to achieve significant value for themselves, right? Are there accountability mechanisms within the African human rights system via which African states can be held accountable for the implementation of the right to development? Now, the short answer is yes. Now, in terms of the accountability, I don't want to make this into a lecture on the African human rights system, but in terms of the accountability mechanism available, I felt I had to give you some background so that what I would say would be intelligible. There are non-contentious mechanisms, periodic reports filed by states saying this is what we have done or not done to implement all the provisions of the African Charter, including Article 22. There is a system of thematic and even country-focused rapporteurs, meaning investigators and researchers who go in and study the issue, either on a thematic basis or on a country basis, and report back to the African Commission. And they also have committees and working groups. There are also contentious mechanisms, and this is what those subgroups have favored. The contentious mechanisms were essentially almost in a quasi-judicial way, or in a judicial way when it gets to the court. Say the endowments people in Kenya will take a case against Kenya, saying that you have violated, among other things, our right to development, and they file what are called communications, which are like petitions to the Commission. They can also bring claims at the African court if all the docs are lined up. Now, so having sort of given you that very quick 2-minute background on the range of mechanisms that are available, I want to illustrate my point about the value added of these hard law norms and their accountability mechanisms by talking about the so-called Endorois case. Endorois case. Now, Endorois case comes from Kenya. In Endorois, excuse me, a Maasai subgroup within who have a lot of land, the graves, the cattle-keeping people. A lot of people might have heard of them because of safaris and things like this in Kenya, complained to the African Commission that the government has seized their lands, ironically, for development purposes, to develop them into upmarket tourist, if you like, attractions and resorts and things like this, without giving them compensation or alternative grazing land for the cattle that they depend for their livelihoods, for their traditions, for their way of life. And this was an area around a lake called the Bogoria in central Kenya. And this was in the 70s. Now, the commission examined this complaint and found indeed that the government, by not consulting the Endorois people, by the Endorois people not participating in those decisions about development that affect their life, had violated the conception of the right to development in Article 22. Now, if we had time, I could go have a whole paper on the conception of development in Article 22, and also through the cases, another one on through the cases in the commission. Participation has become central. The participation of the very people that you are trying to develop has become central to forming the very notion of development, to taking decisions about what constitutes development. It's not enough for a government to sit in the capital to say that we need to take those people's lands, leave them without compensation and they can fend for themselves because we have a national plan to develop. A top-down notion of development is no longer widely accepted as development, almost, okay? Based on those conceptions, the Commission found that there was a violation of Article 82. Now, clearly, the mere fact that the African Commission, which itself issues non-binding decisions, okay, although interpreting a binding instrument, it didn't go to the court, it didn't have to, had issued this decision, was not on his own going to force Kenya to immediately kowtow and say, okay, and the rest people, come take your land. However, what this did was that it strengthened the hands of the activists who were fighting in local courts, in the court of public opinion in Kenya. They now had, other than their own say-so, a legally binding decision, right, with which to challenge the narrative of the government of justness, of right cause, right, of saying we are developing Kenya as a whole. It seems reasonable. That's why we took their land. But this was an alternative oppositional narrative that challenged and ultimately overcame the government's narrative, because the government did succumb in the end after a year or two and did return the lands to the Ndorois people. Okay? Of course, this is a summary of the case, but this is one way in which having legally binding hard law provisions can, in a very concrete sense, okay, other than just platitudes, lead to real people in real communities benefiting from the right to development. Okay? So basically, this case illustrates the value added of hard law accountability for the right to development. Now I'll leave the African level, if you like, account at this point, and we can say more in discussion. But let me move to the global level. So in terms of the implementation of the right to development at the global level, there is a difficult problem, perhaps more difficult problem of accountability. It's more difficult because at the global level, you don't even have a hard law norm or a hard law provision that you can mobilize on at all, right? What more, a hard law mechanism that gives binding decisions. So it's a difficult problem. And there's insufficient consensus at the global level on the need for even effective accountability mechanisms. You don't have enough consensus yet, and there is a, if you like, north-south divide here that's evident here for the most part. And this divide, as I said at the outset, has been around since the 70s. Now, if you look at this slide 11, I have sort of, if you like, unpacked the dominant South rhetoric, countries of the South, developing countries on the right to development historically. Just very quickly for background, you will see that developing countries or countries of the global South historically argued, not all of them, because there's diversity within the South, but in general, they generally argued that the right to development is an extension of their right to self-determination, that the right to development is superior to every other right, which sometimes tended to mask authoritarian agendas. If you say you develop, for example, the government of Kenya saying the right of Kenya as a whole to develop should subsume the right of the Ndorois, for instance, right? It's a kind of top-down authoritarian way of looking at it. And the Ndorois case actually then subverts that authoritarian notion. And then the right to development was also used in a similar way to bolster domestic regime power. And of course, even these countries of the South were reluctant to assume responsibility for the implementation of the right to development, often passing the buck, if you like, to rich countries to say, well, until the rich countries provided us with money and well, the point is, what have you done, as the Enterprise case illustrates, within the means that you already have. So you also have obligations within the means that are already present in your country, okay? Now, of course, keep in mind, like I said, the diversity within the South, and not every South country thinks alike. On the part of the North, the developed world, there tended to be a denial of the existence, the very existence of the right to development. Doesn't have so much, if you like, purchase these days. Then when that didn't work, there was this move to a right-based development approach, an approach that said development is an individual right, okay, which didn't make too much sense. Like saying language is an individual right. I mean, if you're found speaking to yourself all the time, people might have questions, right? So certain rights are simply not individual rights. So to speak of a developmental right, your right to personal development, doesn't tend to make sense when you're talking about, these kinds of transformations, ending poverty and things like that we're talking about. And that's not to say that you squeeze out individual rights. That's not what I'm saying. But that when you speak of the right to development itself. So there was this kind of, if you like, opposition, North-South divide on the question. Okay. Now, excuse me. Now, in terms of the redefining the agenda, the major controversy, as you can see, about the implementation of the right to development boils down to the question of obligation. Now, right? Well, that's basically what is living and dead after the 70s, 80s debate about the existence or otherwise of the right to development is a question of obligation. Who bears the obligation? Basically, who's going to ferret out the cash, the capital, the technology, and all that? Who is accountable for it, and who's going to hold them accountable? That is my contention. That is what remains from that debate. And I've already given you the background of what the high-level panel's report says, what the Secretary General's report says, what the SDG document says. But the troubling question remains, what kind of international legal instrument or what manner of norm is best suited to implement meaningful international accountability? Is it soft law, meaning non-binding law, or is it hard law? Okay? Well, hard law matters, as that judge was saying there. Hard law matters, right? And I call it the wonderful artificiality of law. It's actually a play from Mati Koskiniemi's paper about the wonderful artificiality of states. We all know that states are very artificial, yet we love them so much. Why? We all know. There are no actual borders, which is why a certain candidate wants to build walls. Right? The borders are actually figments of our imagination, man. But the artificiality is still wonderful. It still does a lot for us. Right? So this is often what I say to people who say, well, it's all artificial to say it's soft law, hard law. Yes. But there is something about that artificiality that does something for us. There is something wonderful about it. Right? So on the international level, you might say, where's the sheriff that might enforce this? Right? It's all artificial, calling it soft law, hard law. But my contention that is not the case. And what I've done here is to lay out the case why hard law matters. Not that soft law does not matter. That's not my argument. I'm not saying soft law. I'm just saying that there is some value added, especially in current circumstances, for hard law. So what's the argument? Hard law can, in this case, advance greater compliance. Why? I illustrated, for example, what it did in Honduras, for instance. Framing a norm as law, as something called law, is hardly an idle exercise. There's a reason we frame it as law and not as guidelines, for instance, right? There's something that goes on in our mind when we frame something as law, right? That framing exercise itself disciplines, and I use discipline in the sense of theory, of Foucault, of saying that it conditions you toward compliance. Just that notion that something is law, as opposed to non-binding, okay? So that's my first point. The second point is that hard law reduces, sorry, it's not filed, the field, that's a typo, the field of argument, in a way that political non-binding agreements simply do not, right? Hard law reduces it. It does not eliminate argument. We all know that we can argue, we're all lawyers, we can argue till the cows come home about any rule, right? But what it does is it reduces the field and narrows it to acceptable limits, right? And draws is like playing within a ballpark. You're not playing the baseball game within the entire city. You're playing it within a narrower ballpark. That's what law does, okay? And states then can no longer, for example, cite the fact that the norm is non-binding for them not complying. You take away from the hand of states that argument. And that has value. In their contention with groups, activists usually, who want to delegitimize the argument of the state, right? One of the arguments of the state is that we didn't break any laws, this wasn't binding. And you'd be surprised that, for example, a state like Canada says that all the time to the UN, in the face of UN decisions. Oh, it's not binding, so we didn't do anything wrong. What you do is you take that away, that argument away, and say, why is binding? Find another argument, right? Again, you constrain them and reduce the field of maneuver, the wiggle room available for the state, okay? And then, hard law, therefore, strengthens the hands of activists in the manner in which, for example, I illustrated with endurance, okay? Now, of course, we still need soft law, okay? So I just wanted to flag that, and I could not end this part of the lecture without flagging a quote from my old teacher, Ivan Head, who, in this respect, argued that the great Canadian scholar Ivan Head, that an element of law, some measure of it, will be needed in the effort to realize the right to development. Okay? And he said this in the 70s. So I could not but flag his I think, wise words. Okay. Almost ending. So basically, in concluding, or in lieu of a conclusion, if you like, we started by pointing out the 5 big, huge, transformative shifts that the UN, if you like, discuss and practice around the implementation of the right to development had, if you like, said is absolutely required and necessary if we were to make progress. But we contrasted that with the accountability gap, which was produced by that very same discourse. And we asked the question, how is this going to work? If you're going to make this radical progress, and yet you have this gaping accountability gap, and you have kept on doing the same thing and expecting a different result, how likely is it that we're going to make this great leap forward? Okay? And that's sort of the overarching narrative of the lecture. So, a variety of norms are needed will be my own conclusion. Hard law is definitely an element of hard law is needed while we keep on using soft law. Law, including hard law, is an artificial device, I agree, but it can be malleable and made to achieve any purpose that we want, provided the objectives are clarified at the outset. Now, if I sounded rather dampening on your spirits, remember that hope spring the standard. Okay? Thank you so much.